My goal of this talk is to try and give some guidelines to medical professionals and others who want to use images as part of their scholarly product without infringing intellectual property right laws. I have a couple of disclaimers here. Here's the first one. Ironically, for a lecture which is talking about copyright protection, it contains a whole bunch of images I don't have the copyright for. If any images belong with you, that you were the original author of in this lecture and you wish me to take it down, please let me know and they will be promptly removed. More about this disclaimer later. My second disclaimer is this is not formal legal advice. I'm not a lawyer, I'm a physician. I did consult with a copyright lawyer who reviewed this advice and said it was consistent with the known laws, but don't sue me if I'm wrong. When I got asked to give this lecture, which I gave originally at the Association of University Radiologists in 2012, I pretty much tied myself in knots trying to do the research. It turned out to be a subject that was a lot more complicated than I had originally anticipated. It also turns out that the laws regarding image copyright in the digital age, where so many images are so freely downloadable, has become increasingly difficult to interpret and also to apply appropriately. And then there was a challenge of how to make a talk on copyright not be as dry as toast. So we have a lot of sources for medical images. They may have come from your institution, or they may have come from somebody else's institution, or a colleague, another radiologist, for example. We may have got them from a journal or a book, or downloaded them from a web, or they may be our original images that we've either taken the image, for example, of a patient, or an image that we have drawn or manufactured in some means. We also use these images in a variety of different formats. We may use them in our lectures to our trainees, either locally or nationally. We may be submitting them into a journal or a book chapter, uploading them onto a website, or putting them into handouts for our learners. When we do lectures, we may lecture at our own hospital or medical school. We may be lecturing nationally or internationally. It may be a course for which people are not paying to attend, or it may be a paid-for CME course. That lecture might be recorded and posted on the web, or our slides may be taken and posted as individual slides or as a PDF on a website, or given as handouts to the attendees. The attendees may or may not be paying for those handouts. So I thought I'd start here with this question. Here's an image that I have Googled and I've downloaded from the web. How can I use this that I don't infringe image copyright, intellectual property right laws? Is it okay if I just include an attribution on the bottom, a citation of where I downloaded it from? And if that's okay, how small can I make that font and it still not cause issues with copyright violations? How about if there's a watermark on the image? Does it then make it okay as long as I include that watermark? Or perhaps it's not okay to use that image in any formal means. Before we start, we really need to be clear about the difference between plagiarism and copyright. So plagiarism is actually pretty easy to define. This is just you're taking somebody else's work or ideas and you're passing them off as being your own. And generally speaking, for images, plagiarism is not going to be an issue. Plagiarism is a very important scientific, ethical issue. It's so easy to do a copy and paste these days, and this is one of the reasons that we include citations in our articles to prevent us from plagiarism. So you can avoid plagiarism by just including an attribution at the bottom or a citation to say where you got that image from. Copyright, however, is a whole different beast. And I'm giving you here the formal definition of copyright: the exclusive legal right to reproduce, publish, sell, or distribute the matter and form of something as a literary, musical, and artistic work. And copyright laws were developed long before the development of any form of a digital media, and this has been part of the problem. To have copyright on something, it has to be your own creation. So how does one even get copyright? Say I took this picture of a riverbed in New Hampshire. I really like it. I've posted it on my Facebook page, but maybe I want to submit it to a calendar that I'm going to sell in a year or two's time, and I think, well, I better get copyright on that. Perhaps me just putting the little C copyright sign and my name and date at the bottom is enough. Well, it turns out that copyright is automatic. You don't actually have to apply for copyright. As soon as a product of any sort or work is put into any form of an enduring medium, including digital, we're obviously talking about images in this case, the author of that work has automatic copyright. Now note the phrase enduring medium here. Your ideas, your creativity cannot be copyright. So even if you explained to a colleague a picture that you wanted to paint in exact and graphic detail, and then they went and did it ahead of you, or some other form of a product, that idea cannot be copyright. You cannot sue them for copyright unless you had already put it into an enduring medium. Or only original ideas are copyrightable. This leads to some rather strange things, like you can't copyright a mathematical formula, for example. And you can't copyright facts, so the phone book is not copyrightable. So this is kind of interesting when it comes to medical images, because one could say that a CT scan of a patient, for example, is not really an original creation. It's really a factual representation of the state of their internal organs. This is not something that's been tested in court, to my knowledge. Objects that are considered utilitarian also cannot be covered under copyright laws. So weirdly enough, the fabric and the buttons and buckles that might go into an item of clothing are covered, but the clothing design itself is considered utilitarian and is not covered for copyright protection. Obviously, this is a source of great frustration to clothes designers. It's important to note that the copyright covers both the original work and any derivative of that work. So if, for example, I'd found this image on the left, which came from a greeting card, and decided that I wanted to make some fabric from it, and I took the image and shrunk it, mosaicked it, as you see on the image on the right, I still do not own the copyright on that new image. The copyright on that derivative is owned by the original author. Even if the work is transformed into another form, as long as it's still recognizable as the original, it is covered by the original copyright. So Walt Disney owns a copyright to all forms of Mickey Mouse, whether it's a soft toy, it's plastic, it's made of metal, whether it's a picture, so not just the original film character. This actually means that if you took this photograph here of an actress cuddling Disney while you were visiting the Disney park, while you may own the copyright to that image, if you took it, they own the copyright to the part that has the Mickey Mouse in it. So how do you maintain your intellectual property rights? Well, as I said, you are given them automatically, that you don't need to apply for copyright protection. However, it is certainly advisable, if you have an image or any other work for that matter that you are particularly interested in keeping your intellectual property, you include some kind of a written statement or copyright or other mark, or you apply for Creative Commons license. You can also formally register your copyright at the governmental site. So you can go to this site I have here, www.copyright.gov, pay $35 and you can register it. But you only really need to have formal copyright registration to be able to enforce copyright law. And you can get this retrospectively. So if you decide somebody's affecting your intellectual property, you can at that point apply to have that image copyright registered. Just to mention a little bit about Creative Commons licenses. Creative Commons is a not-for-profit, and what this has been set up to do is to enable the use and distribution within certain restrictions of material, particularly that's developed for educational use, but not only that. If you go to Creative Commons, you can define what license you wish to assign to your work, whether you want people to attribute it always to you, whether they can use it commercially or not, whether they can make a derivative of it, or whether perhaps you wish to put it into the public domain. You download these little icons, you combine which icons you want, and then you put those onto your web page, or you put them onto an image or other work. So does copyright expire? Well, the rules are kind of complicated, but generally speaking, it's 70 years after the death of the author, or 120 years after the creation of the work if the author is either unknown or the time of their death is unknown. So let's come back to medical images and who owns the copyright of this CT scanner, this patient with right-sided hydronephrosis that I downloaded from the PACS station and put into my teaching file. So who owns the copyright to a medical image such as this? Is it me? I'm the radiologist who read the study. My name's on the report. I've downloaded it and put it into my teaching database. Is it the patient? After all, his kidneys, his hydronephrosis. He's paid for the study to be done, or his insurance company did. Or is it the institution that acquired the images, that owns the CT scanner and so on? Well, it turns out that if an image has patient identifiers on it, such as the one on the top left, and it's mine, so I'm not contravening any HIPAA regulations here, then the patient owns the copyright. But an anonymous image, the same image on the right, with the patient identifiers taken off, the copyright is owned by the institution, not by the radiologist or anyone else who downloaded it. So this is kind of interesting because we sign copyright transfer forms all the time when we submit an article. And that's making the assumption that those are our images, or at least the copyright belonged to us in the first place. But really, it doesn't. So let's move on to what is the fair use law. This was brought into effect to provide some kind of a balance between protecting the creator of any work and promoting the interests of the public, and it applies to very specific circumstances. It allows copyrighted works to be used without any permission for the benefit of the public, but there are very limited and reasonable uses for which this can be applied. And here's the direct legal blurb that this law comes with that you can read here, but of note, it covers teaching, scholarship, and research. These are not felt to be infringement of copyrights. Note that the fair use law doesn't prevent a copyright infringement case being filed against you, but it provides a defense in case that does occur. So what are some of the criteria which a court will look at in copyright cases where fair use is being used for a defense? Well, they're going to look at the nature of the original work. Did this work provide some kind of a financial benefit to the original author? They're going to look at how the material's transformed. Is it in a completely different state that's for a completely different purpose than the original work, or has a picture just been transformed to another picture, for example? What is it being used for? Are you using it for monetary gain, or are you using it for educational purposes, for informing the public, research, etc.? Has it had any effect upon the market value of the original work, and how much of the material have you used? Here's an example of transformation. This was an image that, say, originally was being used to sell a luxury car, but if I was using it to educate teens about not talking and driving, then I have transformed its purpose, even though I have not altered the image at all. Or here's an image I've downloaded from StatDX. Now, if I put that into a CD-ROM, even if I was only using a small part of that image, which I was then making commercially available, it would not be covered. But if I was using it in a lecture to my residents, that would be covered under fair use. It depends how much you use. If you're going to photocopy an entire textbook and hand it out to your residents, that's not going to be covered under fair use. But if you're photocopying a few pages and just giving it to the few residents you're working with in a group, that would be covered. Now, there are many images which are in the public domain. Public domains means we can use them, there's no copyright on them, and we don't have to get permission. These may be ones that the copyright has expired, that has been forfeited voluntarily by people, or that things such are images where there is no applicable copyright that can be applied. For example, anything that's produced by the government cannot be copyrighted, interestingly enough. And there's a bunch of repositories on the web that you can find if you just Google them. Just because an image is instantly recognizable doesn't make it public domain. The Golden Arches of McDonald's is still copyrighted. Many software programs, such as those in Microsoft Office, contain a large amount of clip art, which you can use freely, that are copyright free. You just search for photographs. I'm looking here for CT scan, for example, and several images come up. With the growth of the internet, it can be extremely challenging to even find out who does own the copyright of an image that you find on the web. If you go into Google Image, one of the options you have is search for this image. It's actually quite powerful function of the program. And you can see when I searched for this image, there were 293 pages came up which contained this single image. And it can be extremely difficult to tell who was the original author of a lot of web-based images out there. So let's get back to some radiological images. I have two images from a CT scan here of a patient with pulmonary emboli. And image A is just slightly cranial to image B. And I've published image A in a journal previously. Now I'm writing a book chapter. Can I publish image B as an example of pulmonary emboli? And the answer is yes, I can. These are completely different images. There are, however, a few journals out there who have begun to ask for the entire image stack to be submitted to them, and they then acquire copyright on the entire image stack, even though they're only publishing one image. And you must be aware of this if you're publishing in one of those journals. How about this case? This is the same image, but on image B, I have annotated the image with some arrows. Can I now publish the annotated image without worrying about copyright infringement? And the answer is no. This is a derivative image, it's not a new image, and you must obtain copyright release from the original publication. What about this case where I'm just doing a magnified cropped area of the original image? Again, this is really a derivative image that still can be used for diagnostic or interpretive purposes, and in this case, again, you should acquire copyright release. What about in this case where maybe a small thumbnail is just being used as an indicator or hyperlink to a different site? Well, this is usually considered okay. You're transforming the purpose of the image. It's not being used for diagnostic purposes in this case. So how can we try and keep ourselves out of legal trouble when we're using images in our scholarly products? First of all, note that ignorance is no defense. It isn't anywhere in law, and copyright law is the same as any other. Generally speaking, using the vast majority of images in your lectures is going to be okay. You should always give credit where possible. I'd be very careful using stock images for which you have not obtained permission, or you're using them outside of the terms of their license, particularly if your talk is going to be recorded or distributed in some other type of format, such as a CD-ROM or in notes given to the audience. Handouts are generally considered okay when it's one per student and you're not copying vast amounts of material from the original product. Similarly for handouts, usually one handout per learner is considered okay, but it depends what volume of material you've put in it. Handing out an entire textbook is not okay. Handing out a few pages from a journal article is probably okay. You must obtain copyright release before you publish any images or you put them into any form of commercially available product, such as a CD-ROM or an online program. Of note, the RSNA, with its journal articles, radiology and radiographics, and there are other journals out there, have changed their policies such that the copyright of images actually stays with the author, which I think is an excellent move. What about educational websites? This is a little bit more of a grey area. I would be careful. It's unlikely that you're going to get sued about anything that you put up here. But again, I'd be very careful with images obtained from any commercial company. Unless, of course, you have paid for them and you're using them within the criteria that they have given you. So how do you avoid trouble? Well, wherever possible, you get permission, and certainly never publish without permission. And don't forget that your own previously published images do need permission from the prior publisher if you plan to submit them to another journal or for a book chapter, for example. Be very careful of stock images that you have not paid for, even when they're watermarked, and certainly don't ever crop off copyright or watermarks from those images. If you should attribute them if the author's known. An educational video such as this uploaded to YouTube is unlikely to get you into trouble if it has a few images in for non-copyright sources. However, Again, be very careful when you have images from commercial sources, or you have videos, for example, where there is a clip from a commercial source. There are some safe forms of images. You can use images you've paid for from stock images. Note these all come with a very specific license, which will tell you what you can use it for. Usually you have to pay more if you want to use it for a commercial purpose. You can get images with a Creative Commons license and use within that license, or Wikipedia Commons. Images are in the public domain, as we talked about before, clip art, or images that you have taken or manufactured yourself in some form. And I can't say enough how you need to be extremely careful with all commercial products. The stock image companies have software. They regularly look for images of theirs on the web, and they will hunt you down. Most institutions have a code of best practice regarding copyright. It's usually obtained from the library if you check the library websites. And if you adhere to this code of best practice, you're going to have the decreased risk to you with your scholarly works. I'm just going to mention briefly the Digital Millennium Copyright Act, which was written to try and bring some of the older copyright laws up to date with the digital era. If you get a DMCA takedown notice, as it's called, that means that you have put material up on the web that somebody feels is inappropriate, that violates their copyright, you should remove the material immediately. Even removing the material may not necessarily prevent a lawsuit, but certainly not removing it will likely to invoke one. I would recommend that you consider including a fair use statement, such as the one that I had at the beginning of this talk, at the beginning of a lecture that contains images for which you have not got copyright release. This may provide some protection, but it's obviously no guarantee. I had a shorter version of this at the beginning of my talk, but here's an example of a longer fair use statement that could be put on a website, for example. And finally, it's really all about the money. For somebody to succeed at copyright litigation, particularly with a fair use law, they have to show that they have potentially or in reality lost some kind of financial reward by your use of that image. Well, as I said, copyright clear as mud, but hopefully I've given you a few guidelines to help you in the scholarly use of images.